This is Lecture 10.4 for Psych 440, Employment Law. In this lecture, we're going to start talking about the basics and the foundations for employment law. That's a topic we'll pick up again in the next module. But throughout this module and the next, we're going to narrow our focus a little bit. We're going to talk mostly about laws that prohibit discrimination in employment settings. These are certainly not the only legal issues that are relevant to organizations. Your textbook mentions some of them in other places. For example, safety laws, laws about working hours and overtime, or drug testing in the workplace. Those are certainly important, and IO psychologists do look at the impact of those laws, but that's not what we're going to be focusing on right here. In particular, in this lecture today, we're going to focus on identifying exactly who is and who is not protected from discrimination in the workplace. And we're going to focus on the key federal laws that cover who is and is not protected. So just to start out, there's a question over on the right side. This one seems appropriate as I'm recording in an election year. Imagine that you have an employee who works for a company owned by Donald Trump, comes to work one afternoon with a Bernie Sanders sticker on his car. If the employer chooses to fire him on the basis of his political expression, would that be an act of illegal discrimination? As it happens, that was a perfectly legal thing for the employer to do in that scenario. In fact, there was a very widely publicized case in 2004 in 2004, where exactly that thing happened, where a woman came to work one day with a John Kerry bumper sticker on her car. Her employer was a big supporter of George W. Bush, told her, hey, you need to go take that sticker off your car or you don't work here anymore. She said, you've got to be joking. I'm not taking that sticker off my car. She didn't take the sticker off her car. Her manager came back to her a few minutes later and said, no, you need to pack up your things and leave. The case garnered lots of national media attention. I think, in fact, the Kerry campaign offered her a job, but the employer was well within his legal rights to fire her because of her political expression. The reason for that is that by default, most employment relationships in the U.S. are what's called employment at will relationships. There's no particular law that sets this out. It's what's known as a common law agreement, meaning something that people assume is going to be the case unless there's some kind of a formal contract that specifically states otherwise. Employment at will means that either the employer or the employee can start or end that relationship at any time for any reason or no reason. So you hear sometimes about employers saying, well, I won't hire an employee who doesn't come in with their shoes shined, or I won't hire an applicant who comes in and doesn't have their nails done. Those aren't what we as IO psychologists would call good bases for selection decisions, but they're perfectly legal. There's nothing in employment law that says you have to make good employment decisions. Anti-discrimination law just imposes a few limits around this. Basically, it says you can do anything you want if you're the employer, except violate these handful of provisions. Essentially, you can make all the dumb employment decisions you want. They don't have to be good or sensible employment decisions, as long as you're not making those decisions based on whether or not a particular employee is a member of a protected class. That is very clearly spelled out in federal law. According to the Civil Rights Act of 1964 and amended in 1991, protected classes include race, color, sex, which they argued applies to pregnancy and childbirth status, national origin, and religion. There are also specific federal laws, which we'll cover in the next module, that protect people on the basis of age, disability, and Vietnam veteran status. Again, These guys, these categories here are federally protected classes. State laws can add to these, but they cannot take them away, and we'll talk more about that in a second. Now, the term protected class sometimes trips people up a little bit. Members of any race, color, sex, national origin, and religion are protected here. Not just minority groups, not just historically underrepresented or disadvantaged groups. So a few years back, when there was a court case filed by a group of primarily white firefighters who said they had been passed over for promotion in favor of minority employees who were not as qualified, they did in fact have a case, because the argument was not that people of a particular race were or weren't being disadvantaged. It was that race was being taken into account as a factor in making that decision. That is what is illegal. You cannot make decisions, employment decisions, on the basis of any of these characteristics. On the flip side of that, if you believe that discrimination occurred in a particular situation, the argument that you have to make is that at least one of these factors had a major influence on that personnel decision. So on the one hand, everyone is protected, but we are not all protected all the time. If you are fired from your job, you can't automatically claim discrimination on the basis of your race, color, sex, national origin, or religion unless you can show that one of those factors seemed like it played an important role in that decision. We'll talk a little bit more about how that process works in the next lecture, but for right now it's important to know the critical federal laws that form the basis for anti-discrimination law in general. The first key pieces of anti-discrimination law are the 5th and 14th Amendments to the U.S. Constitution. Both of these address the issue of equal protection under the law. These apply primarily to government jobs because it's stating the government is the one who has the responsibility not to deny equal protection. If you file a complaint under one of these laws, you must be able to show that the organization discriminated intentionally. And that's kind of a difficult bar to meet. That's not always the most straightforward thing to show in a court case. The Civil Rights Acts of 1964 and 1991 are a lot broader. These apply to all organizations, including private sector organizations, and they do not necessarily require that you be able to show that discrimination was intentional. Even unintentional discrimination can still violate the Civil Rights Act of 1964 and 1991. These are the key laws, the biggest laws, identifying who is and who is not a member of a protected group. There are also state laws regarding discrimination. Now, states can add protected groups to the list, but they cannot take groups off the list. So, for example, right now, at this particular point in time, there are 19 states that prohibit discrimination on the basis of sexual orientation. There are 31 states that do not prohibit that kind of discrimination. So if you're an organization that's working in multiple states, you have to pay attention to the relevant laws in every state that you work in when you form your hiring policies. For those of you who are located in Colorado, or just to give you a taste of what these state laws might look like, Colorado currently prohibits discrimination on the basis of, well, everything covered in federal law, disability. Colorado's laws specifically include mental disabilities or learning disabilities. Colorado prohibits sexual orientation discrimination, discrimination on the basis of having AIDS or HIV, behavior that is legal outside of work. So, for one example, you cannot be fired for getting drunk outside of work because would be impermissible on the job, but it's perfectly legal off the job. You cannot be discriminated against on the basis of mental illness, transgender status, being married to or planning to marry another employee, or opposing a discriminatory practice or filing a discrimination claim. Now, as you can imagine, these laws vary quite a bit from state to state, and it can be a little challenging to keep track of all of them. A question should be coming up on the right here. Question is really about, is anti-discrimination law mostly concerned about hiring? Or if an organization sends all of its white employees to a training course and fails to send its black employees to that same course, is that illegal discrimination? The answer there is yes, indeed. That could be considered illegal discrimination. Because what the Civil Rights Act states is that it is illegal to discriminate on the basis of membership in a protected class in any employment decisions. So that includes selection, compensation, where you assign employees, who you transfer, who you lay off, how you recruit, what kinds of tests you use, things like use of company facilities. If an organization provides a golf club membership for all of its male executives, it is expected to also provide that same membership to its female executives, rather than making stereotypical assumptions that men prefer to play golf and women don't prefer to play golf. Benefits, pay, retirement plans, any decision that affects a person's employment status is potentially a legally protected decision under employment discrimination law. This also includes your physical and your psychological working conditions. In the next module, we'll talk a little bit about sexual harassment, where you might have heard the term a hostile work environment. Creating a hostile work environment is considered discrimination because it's creating different working conditions for a person on the basis of their membership in a protected group, on the membership of their sex or their race or their religion. The idea here is that if a person is being harassed, if the work environment is being made so intolerable that a reasonable person would not be able to stay, you are affecting the conditions of a person's employment on the basis of their membership in this protected group. So anti-discrimination law is definitely concerned with quite a bit that goes on in organizations outside just the context of hiring. That tends to be where it gets the most attention, but certainly we've got plenty of case histories showing discrimination happening at any and all of these levels. Now this is about the point at which people say, but wait, aren't there some legitimate exceptions to this? And there are a few situations in which an organization can argue that it has a legitimate preference for members of a particular group. In particular, written right into the Civil Rights Act is an exception for religious organizations if the organization's work is clearly religious in nature. So, certainly, a Baptist church would not be expected to hire a Jewish head pastor. That would be considered a legitimate basis, a legitimate situation where you could prefer a member of a particular religion. Religious schools, the argument is generally that training in a particular religion is part of the work of that organization, and so a school can prefer members of a particular religious group. On the other hand, when the work of the organization is not religious in nature, then you cannot make the argument that you prefer employees from a particular religion. So a retail store that happens to be owned by members of a particular religion cannot claim an exemption on religious grounds from anti-discrimination law. They need to hire people equally without regard to religion. There are also exemptions for very small organizations. In particular, if you work for a company that has less than 15 employees, it would be very hard for someone to file a discrimination charge against you. One of the things that becomes important in showing discrimination in a court case is very often showing that there's a pattern. And so with such a small number of employees, there aren't going to be many hiring decisions in the course of a year. So with 15 employees or fewer, it's often just impossible to prove. So very small family organizations can often have whatever kinds of preferences they want and not face discrimination charges until they get above those 15 employees. And finally, there are a few very, very tiny exceptions that are written into the law. You can legally discriminate as much as you want against communists. You can legally discriminate in favor of Native Americans. And you can legally discriminate on the basis of national origin, or some of these other characteristics if you can argue that there is a national security interest. So if you wanted to go to work for the FBI or the National Security Agency, very often groups like that will have requirements that you be a U.S. citizen. Ordinary private businesses are not allowed to require that their employees be U.S. citizens, just that they be legally eligible to work in the U.S. But if you can argue that there is a national security interest, you can often justify an explicit preference for U.S. citizens. So that's the foundation for employment law in the U.S. This idea of avoiding discrimination in any employment decisions on the basis of membership in a protected group. In our next module, we'll talk much more about some of the nuances of employment law, how some of these pan out, and things that you should be aware of as an employee or a potential employer. And we'll start that off with discussing what it looks like when someone does file a charge of discrimination. What does the plaintiff have to show? What does the organization have to do to defend itself against that accusation?